Okay, Doug from Salt Lake. Real quick one. Sunday night, Sunday afternoon, excuse me. And it is April 18th, 11 o'clock in the morning. So, docketing statement and a transcript is what the appeal court needs for appellate procedure. And what is a docketing statement? Well, let's look at the definition. Okay, it doesn't fit in there, but a docketing statement is a statement that is filed at the beginning of the appeal. Docketing statement facilitates efficient processing of appeals by allowing the Court of Appeal to quickly identify problems, jurisdictional problems, appropriate things in the case, and all that. So that's why you put that in. So, docketing statement that I put in comes now. Real party in interest, making a special appearance. I do assert the following mistakes. I will be referring to the page and line number of the transcript. Remember, you have to have a transcript. I already got that. I already showed that to you. So what's the errors and what's the mistakes? Well, the court made a mistake by assuming I was the plaintiff, right? That's where they assume jurisdiction over you. They think that you are the all-cap name. I, Mr. Moomey, am a man, and I am representing my private trust. And I put the trust documents in. I filed it a long time ago in the case. This is also confirmed by the amended complaint that I filled out. It says page 1, paragraph 3, the parties, where it states I am appearing in my proper person, proceeding sui juris, which means of the age of majority and competent to handle my own affairs. Proof I am not a legal fiction and I am not pro se. Okay. They kept saying, "Oh, well, you're representing yourself. You're pro se." No, I'm not. Okay, and that's all in the amended complaint. So that's where they made a mistake. They assumed that I was the all-cap name and not my private trust. The court made a mistake assuming that I was here for a hearing for an argument. There is no argument. If you guys go back, you know the administrative process and the amended complaint spells it out very clearly. There is no argument. There is no dispute. This case has been decided administratively before court. I was just asking for a judge, a real judge, not an administrator, to look over my administrative process and grant summary judgment. The court erred by allowing third party hearsay to be added to the record and used in this case. Mr. Stone, the judge, I don't call him judge or your honor, it's Mr. Stone, should not have allowed this. By allowing this hearsay, he violated procedure and used hearsay to make his decision. That right there should, get the case thrown out right there and remanded back. So the court erred by dismissing this case even after I objected and demanded that the AG sign a notice of liability so that she would take responsibility for the words that she was trying to add to the record. She did not. Everything she said should be struck from the record, and that makes the conclusion of the court erroneous, which means there is an error. Remand is appropriate, and ORS should be subpoenaed to appear and prove they have a claim on my private property. So, private trust, everything's in there, UCC filings, financing statement, who's the debtor, who's the creditor. It's all in the commercial chamber. I'm there representing my private trust, okay? And, if somebody has a claim, please bring it forward. You provide a service. So let's see the contract. Based on law, an affidavit must be rebutted and it stands as truth. Based on court procedure, ORS was required to reply to my process and my notarized affidavits. No affidavits or rebuttals to my affidavits were entered, so Mr. Stone allowed hearsay to override my sworn statements. You should remand and demand statements from ORS employees or somebody. The court and the AG's office both assumed there was no contract. That is false. Alyssa Barlow not only contacted me, but signed a document showing an alleged contract for services. Not only do I have proof of a contract between myself and ORS, but this court also knows that all government agencies have an implied contract with the public, and are not immune when they break this social contract. Notice to agent is notice to principal. Okay? If you work for an agency, you have an obligation and a duty to respond and prove your claim. This appellate court knows that contract makes the law. This court also knows that without a damaged party, corpus delicti, we deal in contract with government agencies. It is assumed or undisclosed or implied contracts. By any threat, duress, or coercion done by the courts or its agency is void on its face. And I prove that through my three-step process. This ORS debt does not exist except on a computer as ones and zeros. Demand and remand ORS prove that they have a contract with me. The court ignored lawful notices to him and did not follow upper court precedent. Okay? In other words, I sent him all those judicial notices and memorandums of law and contract and upper court precedent, Trinzi versus Pagliaro. The court should not allow the AG to add to the record any hearsay. And, all that, ignored all of it and just sent it. The court erred in assuming timing was the issue. This is not about something that happened in 2006, bro. This is about an administrative process I did 3 months ago. It's not about ORS's authority to enforce, because they do have authority to enforce child support, okay, against certain persons. Okay, we've been over that before. Or timing. It is about their failure to prove they have a claim on me and my private trust. The court erred in assuming ORS is immune. ORS must be held to account. They are not immune, and this court should remand back for discovery and trial so that I can prove ORS operates under color of law, which we can all do. All you got to do is read their paperwork and read the Federal Manual of Child Support. The court erred by assuming I am responsible for the state of Utah's debt. Now, we all know that the feds grant ORS money. It all goes into the general fund. Go back. I've done, 15 different videos on that. Okay. They get your name. They capitalize it. They attach a social security number with it. That's how child support is based on. It's based on that social security number, and they make you the collateral for that money that they're getting, grant money that they're getting from the feds. The court erred, and I will not pay for services that I have not agreed to by force. The court has also assumed I have acquiesced at some point to ORS's property or surety. Okay, prove it. I have never acquiesced to them. Mr. Stone, the hearing officer, did not grant me rights. Does not grant me rights. The court is obligated to protect me from agencies for violating my rights. He erred by dismissing this case without demanding ORS provide proof of an obligation. This case should be remanded, and Mr. Stone should tell ORS to produce and provide a document with my signature on it agreeing to their services with the terms and conditions. Mr. Stone did not use judicially cognizable reason to grant the motion to dismiss. In other words, he didn't clarify and give a reason for the motion to dismiss. And by the way, I have it all on video. So, not only do I have it on video, I have it on transcript. Okay? And he just said, okay, are you done, Mr. Mooney? Okay, I'm dismissing this case for lack of failure to state a claim. And I said, wait a minute. What are you basing it? Mr. Mooney, don't interrupt me. I made my decision. Okay, well, what are you basing your decision on? Okay, that's it. And then they just turned off the videos and all that. And man, you talk about getting it right up the old pooper. The plaintiff and Mr. Mooney are entitled to know the basis of law and fact on which Mr. Stone relied to grant the motion to dismiss. Yes, I am. This right here, what did you use, dude? You don't have any affidavits from ORS. You don't have any proof they're immune. You don't have any proof of a contract. You don't have any proof of anything. And you used, right, what did I say? Third-party hearsay to be added to the record. And then you use this, okay, to make your decision and dismiss the case. Completely bogus. The court did not clarify what he used or did not give me a reason for his error of granting. The court erred in assuming I am a public status. I am not. I am private. Remand is appropriate, and ORS should be commanded to produce evidence. The court made a mistake by allowing the AG to represent ORS. Now, here's something too, man. You got to read your Constitution, bro. Okay, I think it's Article 6, Section 2, I think. Don't quote me on that. ORS has a right to assistance of counsel. They do not have the right to ignore a summons and have a third party take their place. They have the right to assistance of counsel. They do not have the right to just not show up and present evidence. The court erred in assuming the burden of proof was on me. The burden of proof is on ORS to rebut, and the court failed in its duty to address this. The court also erred and failed by assuming I am a debtor. I am not the debtor to any government agency. I am the creditor. See the UCC filings. The court made a huge mistake by allowing ORS to continue to administer property that they have no lawful claim against. The court also erred by not allowing this case to move forward because the court, ORS, the clerks, the bailiffs, and everyone in the courtroom has a financial interest in law, in family law, in my case. It is much easier for Mr. Stone to dismiss than to expose and then he'll have to recuse himself, and then have to recuse himself. And finally, Mr. Stone allowed what's called novation. You should look that up. He allowed a man to be who clearly has a case against ORS, who proved his claim by an impeccable notarized three-step process. He allowed or is continuing to allow a free man to be used as collateral without consent so the state of Utah and its rogue agencies can receive grant money from the feds. And he dismissed this case because he knows that 99% of people will not appeal, and the district court and the ORS can continue to play this game of using citizens for security and profit. It's despicable. ORS has no jurisdiction over me or my trust. Remand and tell Stone to grant plaintiff's request for adjudication of facts, not hearsay. Child support is voluntary, and anything done by ORS or any agency of any government without consent is void. ORS provides a service. Where's the contract? Okay. And then, of course, your certificate of service. All right. That's a nice, easy one. Peace.